Be ready. Start. However, the commencement as well as the entire investigation, if any, so far done is quashed on the ground that the third appellant bracketed SHO is not clothed with valid legal authority to take up the investigation and proceed with the same within the meaning of section 5A clause 1 of the Prevention of Corruption Act. The observations made by the High Court are unwarranted and the historical anecdote is out of context and inappropriate. If such a view is to be judicially accepted and approved, then it will be tantamount to laying down an alarming proposition that an incoming government under all circumstances should put its seal of approval to all the commissions and omissions of the outgoing government, ignoring even glaring lapses and serious misdeeds and the deleterious and destructive consequences that may follow therefrom. If any information disclosing a cognizable offence is laid before an officer in charge of a police station satisfying the requirements of section 154(1) of the Criminal Procedure Code, the said police officer has no other option except to enter the substance thereof in the prescribed form, that is to say, to register a case on the basis of such information. Though a police officer cannot investigate a cognizable offence, he can investigate a non-cognizable offence under the order of a magistrate having power to try such non-cognizable case or commit the same for trial within the terms under section 155(2) of the code, but subject to section 155(3) of the code. Further, under the newly introduced subsection 4 to section 155, where a case relates to two offences to which at least one is cognizable, the case shall be deemed to be a cognizable case, notwithstanding that the other offences are non-cognizable, and therefore under such circumstances the police officers can investigate such offences with the same powers as he has while investigating a cognizable offence. The core of the sections 156, 157 and 159 of the Code of Criminal Procedure is that if a police officer has reason to suspect the commission of a cognizable offence, he must either proceed with the investigation or cause an investigation to be proceeded with by his subordinate, that in a case where the police officer sees no sufficient ground for investigation. They also argued that considering the age group of the parties, it is in their interest if divorce is granted to them immediately instead of waiting for 6 months as is required under section 13B clause 2 of the Act. Both the counsel argued that if divorce is granted to them without losing this time, the parties may enter into a fresh matrimonial alliance and can resettle in their lives. In Naveen Bansal's case, bracketed supra, a single bench of this court granted divorce under section 13B of the Act, waiving the period of 6 months. In that case, the wife received rupees 3 lakhs as permanent alimony and agreed to get her complaint quashed, which she lodged under section 406 upon 400 98A IPC and under Dowry Prohibition Act. In Ved Kumari's case, Supra, another single bench of this court held that the parties are living separately for the last more than 1 year and there is no likelihood of any reconciliation for their living together. Considering the facts, the single bench held that it will be of no use to keep misapplication pending for statutory period of 6 months as contemplated by section 13b (2) of the Act, as the litigation between the parties is pending for a period of over 4 years and they have not been able to reconcile to live together during this period in spite of efforts of both sides to do so. Hence, period was waived and divorce was granted. In Surinderjit Singh's case, Supra, parties were living separately for more than 6 years. Husband filed a divorce petition which was dismissed. When his appeal was pending before the High Court, parties filed a petition under section 13b of the Act and prayed that the period of 6 months be waived off. Husband paid rupees 25,000 in lump sum to the wife in full and final satisfaction of her claims. The learned judge held that, in his opinion, the parties have reached such a stage where their living together has become impossible and it is a broken marriage. It will be in the interest of both the parties if application for grant of divorce by mutual consent is allowed. Hence, the divorce under section 13b of the Act was granted, waiving off the period of 6 months. In Naresh Kumar's case, Supra, on identical facts, another single bench of this court allowed the petition under section 13b and waived off the period of 6 months under section 13b clause 2 of the Act.